Good morning, everybody. Welcome to our session on AI, the GDPR and regulation. Thank you for battling through the snow in Brussels to make it here. It's going to be worth your trip. It's going to be a very exciting session. In fact, the idea for this session came out of our discussions last year at the CPDP Scientific Committee meeting, where we all agreed CPDP is wonderful. It does slightly suffer from the Brussels effect of everyone sort of cozily, calmly agreeing with each other. And wouldn't it be good to have one or two sessions where we had a little bit more vigorous debate? If you ever watch the comedy that is Prime Minister's Questions in the UK, we're not quite going for that. I had to reassure Mireille. Like, you know, don't sort of shout "Arr!" from the audience when you disagree with things. But we are doing this in the style of the Oxford Union debates. This is a student society at Oxford University that for centuries has been hosting debates, training our very high-quality political leaders, as you all know from Brexit. It has hosted a range of speakers, including Nelson Mandela, Bill Clinton, and my favorite, Kermit the Frog, over the years. The format that we will use is, so as you know from the program, we have a motion which we'll ask you at the start and the finish to vote on, so we can see if our speakers have changed your minds, that this House believes that the GDPR is insufficient to regulate artificial intelligence. We're going to have a slightly more nuanced set of presentations from our speakers than a typical Oxford Union debate, where usually you'll have two people speaking for and two people speaking against the motion in, you know, sort of black and white terms. Our three speakers are going to give slightly more nuanced positions, but then it will be up to you to decide how you will vote on that motion. We have three really wonderful speakers. Furthest from me, of course, I'm sure you know all three of them, but Paul Nemitz, who is from the European Commission DG Justice. He was the lead director on the GDPR. He's currently principal advisor on democracy and technology. And Paul wrote a very interesting paper that has been made open access by the UK's lead scientific academy, the Royal Society, on this topic, which, if you haven't seen already, I can recommend very much. To Paul's right is Professor Mireille Hildebrandt, who is a professor both at VUB in the LSTS group. I know there are quite a number of those people here. Also at Radboud. I'm sorry I mispronounced it. Mireille can pronounce it correctly when she stands up. And Mireille is at the moment the holder of an advanced grant from the European Research Council in this area. And then closest to me is Ben Zevenbergen, who previously worked for a Dutch law firm called Solve, was then an assistant to Marietje Schaake in the European Parliament. I then had the honor to be his PhD supervisor at Oxford University for a number of years, looking at some of these topics. And Ben is currently a research fellow at Princeton University, working with two of my sort of great intellectual heroes, Ed Felton and, astonishingly, Peter Singer. We were just talking last time I saw him. I didn't realize he'd worked with the man who 30 years ago I read one of his books on animal welfare and have been a vegetarian ever since. So, you know, the kind of impact you can have in these topics, very exciting. We want very much for you to be involved. So I'm going to ruthlessly cut the speakers off at 10 minutes. They each only have 10 minutes. I'm not quite as ruthless as the US Congress. I can't switch the microphone off remotely, sadly, but I'll be gesturing furiously if they go over their 10 minutes. And then we want to hear from you, your pithy thoughts, arguments for and against the motion. And we'll see if anyone's mind is changed. So let's just quickly sort of get a sense of the room. On this motion, this House believes that the GDPR is insufficient to regulate artificial intelligence. Who would agree with that statement now? Raise your hand, that the GDPR is insufficient. So I think a majority. Who would vote the opposite? That the GDPR is sufficient to regulate AI. So only two people. Interesting. So actually, let's see if those two people put their hands down at the end, or if more people raise their arms. So, Paul, would you like to speak here or from there? I would suggest the usual style is, you know, vigorous debate, persuasion, Not quite tomato throwing, but if you would,
come to you.
Come, I think yes.
Right.
And pace this. Well, no, don't pace the stage because the mic won't record you.
So thank you very much, and I love these debates. I just said to Mireille, I once narrowly lost such a debate on the slogan or the question, does America need a right to be forgotten? And so today, of course, the room is very much or already convinced that we need more. I would like to make the argument that we have to make a difference when we ask this question between personal data and non-personal data. So as regards the treatment by artificial intelligence programs of personal data, I would say GDPR fully applies and must be rigorously enforced. There is no GDPR-free zone in this. And so as regards personal data, then the question becomes much more precise, namely what would we need in addition to GDPR, in addition to the obligation to make an impact assessment, which cannot stop simply on the technical matters, but also has to look at the legality overall, the rights of access for automated decision making, to the logic of programming and its relevance, the obligation of the controller to give meaningful information about the programming and the use of the system of automated decision making, its impact and relevance. So I would say for personal data, GDPR at least goes very, very far. But it is also important to think about non-personal data and AI. And there, the battlefield of politics and science is really very open. And we need to think about criteria which allow us to decide in a democratic society what subject where we see a challenge to protected interests, fundamental rights, interests of the state, that democracy functions well, and so on. Do we need to regulate by law? What issue do we have to deal with by law? And what issue can we leave safely to ethics and self-regulation? And I would propose a principle which is not only a principle of German constitutional law, but you do find it also in EU law, at least to some extent, although not under the same name. And also in British law, rather recently in the High Court decision on that Westminster has to have the say on how Brexit goes forward, cannot be left to the government alone. And what is this principle? It's the principle of essentiality. This principle says that matters which are essential for society need to be decided in democracy processes, meaning by the legislator. What is essential? Well, it's a rather simple answer. In detail, of course, can become more difficult. Essential is what either touches on fundamental rights of individuals or essential, important matters, very important matters, of the state. For example, the good functioning of elections and democracy. So in these two areas, legislator must act for reasons of democracy, the democracy principle, but also for the reasons of the rule of law, because in these areas, the decisions must be subject to judicial review. They must therefore have a legal basis, and they must also potentially be enforceable against those who don't want to play ball. And these two criteria are the difference to self-regulation and ethics. Self-regulation and ethics, who creates it, and is there democratic legitimacy? Well, probably in all cases less than in the formal parliamentary process. And second question and second difference, can we enforce with the power of the state the rules? And this will normally be the case for law and normally not be the case for self-regulation and ethics. In Europe, there's a third very important concern, namely the level playing field. How do you secure in the internal market the level playing field between competitors? Well, the simple answer so far has been law. Law which is applied, in the end also interpreted in a unified manner by the European Court of Justice for all member states in the same way. And we are still struggling with making this principle work, because even though we have this institutional setup with one court which finally interprets the law for all, hopefully in the same way, in fact, even the law is often applied in member states in a different way, and even where we have law, we still struggle with the level playing field between competitors. Now, a fortiori, what does the issue of level playing field gain or lose if we say, well, you know, the law is too prescriptive, it's a problem for innovation, it's a problem for this and that, let's just leave it to ethics and self-regulation. Namely, let's leave it to companies to choose whether they sign up to rules and don't sign up to rules. My view, why some of the big players in AI are now asking for regulation on, by the way, some very limited aspects, you know, like face recognition, is because those actors who ask, they are worried that they will be subject to very severe public scrutiny and public pressure and public opinion and so on, while others, they will just make the choice not to sign up and make the money in the way in which capitalists have made money since capitalism exists, namely on the edge or even also beyond the edge. And so this concern of a level playing field is a concern not only of policymakers, but it is actually also a concern of those companies who at least, let's say, strive to act legally. So in short, and to conclude, while I would differentiate the answer between personal data being treated by AI or and non-personal data, I would say as a principle, if it is true that AI will be as pervasive as electricity, that it will make the decisions for us or contain the decisions according to which in our society education is dispensed, the transport system is run, health is treated and so on, then the principle of essentiality means that by principle this matter must be dealt with by law, and certainly in the area of non-personal data there's a very open field where we need more regulation. Thank you very much.
Thank you, Paul. Paul mentioned the Miller judgment about Article 50. I wish I had the Daily Mail front page up on the screen with the picture of the 3 judges in our High Court who came to that saying, I think, was that Crush the Saboteurs? I think that was this one. Okay, Mireille.
Shouldn't we do a new vote? Because there are twice as many people as the first. Maybe it's all the against people that
This is true, but they've also heard Paul now. Let's keep it simple.
Simple, you're talking about technology, okay. So first of all, I want to say something very briefly about artificial intelligence, which is of course an overly broad term, means too much. And also I think we need some expectation management as to what AI is actually going to do for us. I think we are now at this very moment witnessing that both companies, the founding fathers of deep learning and others are actually seeing the limitations of data-driven approaches, in the sense that they are still, contrary to a lot of the mythology, one-trick ponies, and that means that though they may have a lot of limitations and not do everything that some people think they do, they are, if we employ them, especially to the extent that they are black boxes and we can't see properly what they are doing and whether they're actually functional, will still have huge implications and consequences. And those consequences are, of course, concerning fundamental rights, and I'm sure that's everybody's concern, but But I think they will also have an enormous impact on safety, security, health, and that sort of stuff. So I believe that we are actually at this moment facing an unhealthy choice architecture. Choice architecture is a term I flicked from nudge theory. I think we always face choice architecture. So which choices do we actually get? So we might be able to have an infrastructure that allows us 16 different choices, but because that's a bit too much, the infrastructure narrows that down to 4. So this will boost our idea that we have a choice and that we're autonomous, but even the types of choices have been premeditated. And that premeditation takes place on a back end of these systems, which is a technical term. What happens behind the screen and is very difficult to see. So this unhealthy choice architecture is not about only the choice architecture for citizens, but also for companies, and that is partly related to what Paul Nemitz just said about the level playing field. What we want from legislation, rather than from ethics, is to put a threshold in the market for fair, but also for safe AI practices. So a choice architecture is basically determined by a market. And I think it is very important to not think that a market is a natural thing, something that is out there that is given, like the wind and the mountains. A market is actually constructed mainly by private law. And private law is not natural law, it's a construction. Freedom of contract, property, alienation, etc. Now, there is a lot more than private law that constitutes, not regulates, constitutes, makes a market. And we have to rethink how we have put together this market. One of the main instruments in relation to data-driven AI is, of course, European data protection law, if we're talking about Europe. I think that has been remedied, and I think to the extent that it's going to be enforced, and I have trust in the court in Luxembourg that they're actually doing that, going to do that. I have little worries about that. I am more worried about things like competition law. I think competition law now is the next in line that has to be rethought. And then we're of course talking about the platform economy, but we're also talking about underlying ideas about what competition law is supposed to do, what it is for, how it could regulate markets. Lina Khan in the United States and Orla Linsky here in the UK have written some really good stuff to really seriously rethink the assumptions of competition law, which are very much aligned with the two Chicago schools of economics. There's of course no time to go into that, but maybe it comes up into the discussion. Another thing is liability law. I think everybody agrees that this has to be updated. The question is, how is it going to be updated? How are we going to assign what liability to which actors in the field of AI? I will give you my position. I think that whoever puts an application with machine learning on the market should be strictly liable for harm and damage caused. That's of course a very limited liability because it requires damage that must be identifiable and proved. This is the ex post approach. It seems to me that we also, in terms of AI, very much need an ex ante approach. So before the stuff comes onto the market, especially when we're thinking of both safety, health, and fundamental rights. So I have a proposal. We all know that when you buy something, there may be this CE label on it. Toys, but all sorts of other stuff. That means there is a prior requirement. If somebody wants to put a product on the EU market, it has to go through some requirements. If you want to make sure that machine learning research design, that is the design that determines the output and whether that output is reliable. If you want to make sure that that research design is reliable, then just like with medical drugs, you will need to require that the research design is pre-registered and that any update of the research design is also pre-registered. This is the first and only business case that I've ever seen for a blockchain, because I think this should be done on a blockchain. So I'm finishing. My point is that we are now witnessing failing and unfair markets. That's not the same thing, but partly they overlap. I think ethical approaches are not enough, because you cannot expect a company to accept an ethical approach that other parties will not take up and then be pushed out of the market. So here the level playing field is very important. Please remember that markets are human constructs, and to a large extent they are legal constructs. They are not forces of nature, like specific economic schools like to have it. Okay, that's what I want to say. Yeah.
Perfect, thanks, Mireille. And by the way, if anyone who's standing at the back would like to sit down, I can see at least 7 free seats towards the front. So please do come up. Perfect. Let's wait 10 seconds, Ben, while people sit down.
Double master, I already suggested to go to have a seminar. One lawyer and one engineering professor, and then students.
Okay.
Thanks, Ian. Thanks for inviting me. I'm really honored to be part of this debate, especially with these scholars that I've always looked up to when I was a student myself. I'd normally never agree to join a panel like this one out of fear of humiliation. But it's due to the significant superiority of my points on defending ethics that I decided to accept. So my point is that AI has more impacts than just data protection, and even more impact beyond rights. So we should, at this point, not develop more new regulations for AI, and neither should we attempt to update them at this current moment. But we should take seriously the toolbox offered by ethics. There are 3 reasons for that, and I'll go into each in a bit of detail. So first, we can use the tools of ethics to make sense of the impact that AI is having on societies and on individuals, and down the line inform legislative action. Ethics is useful to develop codes of professional ethics, enforceable ethics, not these lists of top 10 principles that you keep seeing popping up. And finally, ethics has been useful to establish ethics review, which oftentimes you see it being adopted from the biomedical sciences and applied to technology. But I'm going to argue that actually we need to rethink ethics review in this particular sector, and then it can be useful. Of course, it's important that ethics needs to be understood properly, because oftentimes people argue that in this current state, ethics is being misused to push some self-regulatory agenda. If for every government debate session workshop that I've been in where ethics in AI is discussed, every single time it ends up being a discussion about science fiction and opinion rather than about the technology and indeed ethics as a discipline. So let me make something clear. AI is not a magical solution to anything, and neither is ethics. AI is an umbrella term for a whole range of technologies. I like the description of prediction machines, but there are many other ways of looking at it. And ethics is a set of reasoning methodologies. So to put ethics into context, just a few words on what ethics isn't. Ethics isn't a compliance exercise. It's not some divine global super law that some people subscribe to it, that, you know, that would make everything right. You often hear, well, let's just be ethical and then everything will be okay. Ethics is not a blank check to state your opinions in a debate. It's definitely not a template for self-regulation, and it's definitely not ever a replacement for the rule of law. No serious ethicist will ever claim that. Ethics is, however, it's an academic discipline with several millennia of thought. It's a set of reasoning methodologies, or reasoning tools that help you understand the nature of actions and of consequences. It illuminates the value tensions of decisions that are being made. It can be a guide for argumentation or for debate, and gives, you know, the moral foundations for action, especially once you've assessed all the alternatives critically. So after this long introduction to the point of what I want to get to, and as outlined by Mireille, we're currently in a situation where AI is disrupting and challenging existing laws to a certain extent. Some call that a situation that you're in a policy vacuum, where current laws in the books don't actually regulate the social technical reality on the ground. Whether that's true is up for debate, of course, but if you just look at the media, you know, there's a clear perception that the current governance structures, including laws, including the GDPR, are insufficient to mitigate the harms that emerge by the use of AI. You know, the laws that we've had, they were useful at the time when they were written, most likely, hopefully, but AI is such a disruptive technology that actually it's taken social technology and put it somewhere else, and the laws that are governing this here are now being stretched to govern that situation. That's unhelpful. And let's not forget that ethical principles underpin law, legislative action. So having said that, that brings me to the three solutions. First, in this moment, in this policy vacuum that we're in, let's use the methodologies of ethics to really assess and analyze the situation we're in. Let's use the methodologies to dissect the social issues that are emerging by the implementation and integration of AI technologies in particular sectors or institutions or in markets. Understand, you know, who is affected, who is burdened, how can these situations be remedied, what are the externalities, you know, would regulation even internalize or mitigate these harms? If you would regulate now, I think it would be too burdensome for the current state of the AI research market. What's also interesting in this particular policy vacuum stage is looking at the public debate, and especially at the powerful players who are coming out now with, you know, their ethics guidelines, or whatever they call them. That's also part of the research process. They're all criticized for very good reasons. But look at them, look at what they say, look at what they don't say. Make sure we understand as a society and as policymakers what it is that these companies or governments would rather you not look at in this particular situation, and then analyze that, look through that frame. And I can predict that by doing such, you know, rigorous ethics analysis, some conclusions will be that, you know, optimizing systems for values like fairness and transparency and accountability, that's not doing ethics. That's going to be one of the first solutions. But what that is helpful for is it's thinking about the operationalization of ethical values, thinking about the tensions in practice, in real life situations, and then figuring out how these ethical values that underpin a lot of our laws are being operationalized in technology. The second point that I wanted to make is about professional ethics. So not these Asilomar principles or the Toronto Declaration or whatever. Those are sets of principles. You have the European high-level expert group on AI talking about trustworthiness. You know, that's equating ethics with trustworthiness. That isn't quite right. You have the IEEE looking specifically at things like human welfare. Again, that's not ethics. Those are particular, fairly lofty values. It's interesting, for sure, but that's not what I'm talking about. What I'm talking about is what lawyers have, what doctors have, what researchers have. Enforceable codes of ethics. So these codes of ethics regulate the relationship between the lawyer and the client, or the doctor and the physician and the patient. And lawyers and doctors do have private practices. You don't have to be regulated. It's not only that if you're in a public profession that you can be regulated in this way. Because if you violate those ethics codes, you can lose your license, or you can be disciplined in other ways. So the point of these codes of ethics is that we don't give them to lawyers and doctors and researchers because we like them and they should have different sets of ethics. No, it's because they enable a higher social goal, a higher social value. For doctors, that's justice. For lawyers, it's justice. Doctors, it's public health. Researchers, it's knowledge. It's something that we try to get towards. And by enabling that work to be done within a separate, particular ethical framework with enforceable actions, we can get to a situation where these professions are fairly well regulated. The challenge, obviously, is what is the higher goal that we would give AI developers, or how would we write these for AI developers? And my third point is a genuine internal ethics review. So companies, governments, whichever other organizations that use machine learning and AI techniques, universities, for example, can build their own internal ethics review systems that can say no to certain decisions about AI systems being implemented. And this would definitely go beyond data protection by design or any other such checklist mentality, but it would look at rigorous procedures, a statement of values, rules to make decisions when these values come into tension, which values are higher in hierarchy than others, auditability of these processes, and training within organizations of possibly everyone, and then some people having higher levels of training if they're in some way responsible. So just to conclude quickly, I have to stop. Last sentence then. It took about 6 years for the GDPR to be implemented. That's my own timer. Time is up. It took 6 years for the GDPR to be implemented. If we start looking at new AI regulations and laws now, that's going to take another 4 to 6 years for sure. And in that interim period, we probably won't have much to guide action. So let's use ethics in this interim period to set up these three things and really learn from these experiences to inform what should be regulated and what not and how.
Thank you, Ben. That's great. Good. So thank you to all three speakers for keeping to time, which means we have lots of time for discussion and debate with the audience, which is wonderful. For my planning purposes, if you are thinking there's something you would like to say in the next 30 minutes, could you raise your hand, just so I have a rough idea of numbers? Okay, good. So, can I ask everyone please to be concise? If you want to ask a question, please address it to one panelist, not the whole panel, to make sure we keep time for your discussion. Feel free just to make a comment. You don't have to make a pretend question out of your comment. And if you would mind queuing at the microphone so that we can record those, please. So, and we also have someone with a roving mic, which is great. Who would like to go first? Please.
Good morning. Thank you for your wonderful discussions. My name is Erik Valgaeren. I'm a practicing technology lawyer based here in Brussels. I'm also an alumnus of the Chicago School of Law and Economics. So I was a little intrigued when Paul, at the end of his intervention, referred to electricity. And my question is, if we look at what happens with regulation of electricity and the way governments and supervisory bodies step in, are we really convinced that we are creating the efficiencies we need? Because I think it's an extremely inefficient market. There's a lot of disruption. There's no alignment between supply and demand. And I think we're in for a lot of trouble if that is the way we want to deal with artificial intelligence. So maybe Paul and of course the others, I would appreciate a comment from them.
That's a great question. And people standing at the back, there are still some seats up here if you would like to come up. So let's keep it to Paul. Let's not ask each panelist each question. Paul.
Yes, I think we have to make a difference between the issue of regulating competition and the market on the one hand, and regulation which protects essential interests such as fundamental rights of people, safety, security, or for that matter, the good functioning of democracy. The second type of issues, I would say, is at stake when we talk about AI, and I would say, let's apply the principle of essentiality here, but of course, no of the laws should be against ethics or unethical. Nobody has a problem with, one, the thinking process based on ethics, although I must say from a democracy point of view, I have a little issue. I'm myself a member of the German Data Ethics Commission, yeah, but we suddenly now establish a new class of participants in the debate on how to shape our laws who claim, a certain higher legitimacy. And I'm not sure about this. I mean, I participate in these debates, but I also listen to those who, for example, say, well, in a democratic society, first question is something fixed by the Constitution? If that's not the case, it's a matter of political discretion and therefore political discourse. And in that context, of course, people can say, I am now making an ethical argument, but, does it make the argument more important? Are these people more important in the debate and so on? I'm not sure, and I'm also not sure that the standards of science related to what is claimed to be an ethical argument is really up to speed. I think many things which are called ethics, I heard this also from your presentation, is actually just an opinion as any other. This being said, also to be very clear, no problem with companies or professions going beyond the law in their own ethics codes. But I would see a big difference between the professional codes of free professions, lawyers, doctors, who traditionally speaking have earned their own money, they were not dependent on employers, and they have a history of hundreds of years of setting their own standards, as distinct to what we're talking about in AI, which is mega corporations having thousands of employees and the stock market basically, showing the direction. I think, we could go into this debate very deeply, and we would find out that there's a reason why self-regulation is actually regulated. It's not pure self-regulation. Professional codes and so on, they have a hook to the law. But second, they're also limited to a very narrow field of professions for a reason. So to conclude, with all its failings, the democratic law, I would think, is still the best instrument to shape our society in important matters. And nothing is perfect, also not the law. Surely, it can always be improved. That's the nature of a living democracy. But we live in times where democracy is in the squeeze, on the one hand from populists, on the other hand from technology. And I would say even for that reason, to just show that our democracy still works and can deliver, I would say there should be a certain préavis favorable towards democratic legislators doing their job rather than down-talking the law.
Thank you, Paul. I'm not immediately going to come to Ben. I'm going to take more questions first. Please.
Hi, I'm Robin. I'm studying data science in Eindhoven, and I was really intrigued by Ben about what you said about code of ethics. We have an ethics class in our course. However, I noticed that to my great sorrow, most of my colleagues don't like ethics. So how would you enforce, or how would you expect people, pretty technology-focused people from Eindhoven University to self-regulate in a code of ethics? Because I really want them to take part of this, and I really think it's necessary for the data science or artificial intelligence. But I can't see how I would motivate them to do this, because some of the people I've talked to are like, well, yeah, if I take everything I have, all the data, no matter skin color, race, economic status, and I can make a perfect prediction, that's great, right? So, yeah, that's my question.
A friend of mine is a computer science professor in the UK and teaches a similar course, and he's from Singapore. So his solution is cane the naughty data scientists, but I imagine Ben's not quite that determined.
Yeah, well, I think there are two ways of looking at this. So I'm guessing that your code of ethics or the things that you learn in that class aren't mandatory for the students. Yes. So, you know, if data protection was mandatory, I think most companies dealing with personal data would also not like data protection law and therefore not comply with it. But rules are not there to be liked. They're there to set a level playing field, as we heard earlier. But I think ethics, specifically in data sciences you do, can get really interesting because you have a lot of these conferences called Data Science for Good or something, where thousands of young students come and they want to solve the world's problems. And they think that with enough data and the best algorithms they can. But having short, pointed conversations with each and every one of them, I've learned that actually there are two mindsets in solving a lot of problems. So the mindset that you and your colleagues come with is the consequentialist mindset of, we are going to solve this problem, and it doesn't matter how we do it, as long as that problem is solved, and then it's good because the problem is solved or addressed. But then there's also the various other ethics reasoning methodologies that don't look at the consequences and the ends, but look at the means that you take to get to a certain end. So for example, well, take any example, but using a lot of data, changing lived realities of people's or informational spheres of people's to solve a particular problem can actually also bring about many harms. So once you start thinking differently about the means that you're taking to get towards an end and understand the negative consequences of those means, ethics becomes a really interesting conversation also among technologists who then suddenly have a new way of looking at their work and with this mindset of, we're trying to do good, actually realizing that the steps we're taking aren't that good. It's only the end result that may be considered good. I could go into this for a much longer time. We can talk about it offline.
Thank you. Are you waiting standing, please?
I'm linking it to the last question. I joined the European AI
Could you
group.
speak? The mic, yeah.
Yeah, I joined the AI group that is preparing the guideline. And something that is very interesting is a sort of ethics by design approach. They link to the privacy by design. And I think it's a very interesting approach. And the first guideline have something about these kind of things, self-checking, quality from the design and so on. And I think this can be a sort of mix between not ruling, but having some kind of guidelines.
Great, thank you. Please, next question at the back, and then I'll come to the front next.
Hi. So I think when we talk about artificial intelligence, it is also a large value chain in a way where there are a lot of stakeholders involved. And of course, in a way, if we look at AI as a tool, there are a lot of end users, both from a commercial perspective and also a personal perspective, especially if we talk about prevalent use of AI in the future. So of course, one thing that the GDPR doesn't regulate is household or personal use of personal data. But when we look at, when we talk about the ethical framework, when we talk about the different regulations, should we start thinking about whether there's a need to also regulate personal household use of AI in the future? So right now, GDPR, for instance, would regulate the government use of AI for policing, etc., where it involves personal data. But since AI has potentially a larger impact to other people, for instance, we see potentially self-driving cars where it could potentially involve users inputting their preferences for the tunnel tests, for instance. So we'd just be interested to hear your view on that. Anyone on the panel?
Mireille, please.
Yes, fine.
And could we bring the mic forward to this gentleman, please?
So I'm going to connect that with one of the former questions, which was basically about smart grids and the competition on the energy market. because you're using the example of the smart car. But we could also say all this Internet of Things that is going to come into the home and is already in the home. Connect that with smart grid and smart meters. And there again, I think we have to differentiate between the front end of these systems that we live with, maybe a display that tells you that your washing machine is very expensive in the night and how you can cut down on that. But we also have to think of the back end of these systems. There is, for instance, a nice paper by, I think, data scientists that from your energy usage, that's an interesting event.
The IoT is fighting back.
You can calculate from your energy usage which television programs you have been watching. So this is just an example. The extent to which these types of technologies are, let's say, incentivized by the current market structure around the smart grid, where the network operators are not asked to make money, so they're very conducive to ethics by design and all that. But the energy suppliers, they are competing on a competitive market. So they want to sell you a display so that you can easily see how you can work on reducing your energy intake, but at the same time that company can track your behavior. In this case, data protection law applies. This does not fall under the household exception at all, luckily. But I think this is much more than just data protection law. This is the choice that the European legislator has made to invite competition in one part of the market, so the energy supplies, and not at the network level. And I'm not saying that I know the solution to that. Energy has to be bought on the market. Incoming are the idea of renewable energy. It's an extremely complex market, actually, and it's of course not just a European market. Prices fluctuate per nanosecond, so if you want to anticipate energy usage, for instance, going back to the smart car, if you load electricity of a smart car, I think it takes the amount of energy of about 500 households. So to prevent a problem with load balancing, which would mean a power cut for all of us, the solution is that we continuously predict the energy usage of people who use a car in their household, etc. I have done a report on this, and I actually do not see another solution. We're going to use more electricity because of all the ICT. We will have to go towards renewable energy. There's no other way. This fluctuates enormously, and also the demand fluctuates. So without predictive technologies, I don't see how we can solve that problem. But this is not just a matter of technology. This is how do you incentivize the market? And one of the interesting questions is, and it may be strange for a panelist, but I would challenge the person who asked the question, proudly speaking of coming from the Chicago school. So I would be very interested, should we leave something essential like electricity that is becoming more important every day and that is related to the climate crisis, etc. Should we leave that to the Chicago school idea of market, people as either rational agents, or take the behavioral school, people as irrational agents, but at least they are predictable? These questions come to the forefront, and they are questions of our survival, actually, because of climate change, etc. So I have a question for somebody in the panel, actually.
I'll come back to the speaker, to the question if we have time, but this gentleman, please.
Okay, thank you. I'm David Reiche from the EU Agency for Fundamental Rights, and I have a question for Ben. You were speaking about the need to use ethics and also the operationalization of ethics as where regulation does not kick in. And this obviously, it surprises me that there was complete absence of mentioning of human rights and fundamental rights in your speech, because I would see we have a sort of an operationalization of ethics, which is actually enshrined in law. So we have and you were also speaking about the toolbox, so we have a quite good catalog of rights, like the Charter of Fundamental Rights in the EU, when implementing EU law, the European Convention of Human Rights, and also the UN level toolbox. So I was just wondering what you think, like also if data protection legislation wouldn't kick in, we also have other rights like non-discrimination, dignity, and so forth. So just wondering where you see this.
Yeah, absolutely. And I think I may not have been particularly clear on that one. What I meant by the operationalization is the operationalization of those values, you know, from ethics that have gone into these international human rights law frameworks into technology. So how do you operationalize what we've written down, what we've thought of in the millennia or decennia with human rights in a technology? That's what I meant. So human rights is very much an expression of ethical values in international treaties. How do you take that and build that into a system and let it actually work to enhance or enable those rights for individuals? That's what I meant.
Thanks, Ben. I think we have someone, yeah.
Hi, my name is Eugene Burmaka. I'm studying the law at the University of Oslo. I have a question to Mireille. While talking about unhealthy choice architecture, you mentioned some issues which are, in my opinion, not directly connected to data protection, such as health, security, and safety. Why do you think that existing product liability approaches and product safety approaches available in the European Union are not sufficient in this area?
Well, that can be answered very shortly. The product liability directive is not necessarily applicable to AI. That's one, so we have to think about how to do that. There's a long discussion about to what extent that should be applicable to services and to software. That's one, and the other one is that the machinery directive that regulates this CE label, which is now in consultation, it's going to be updated, is also not applicable to these sort of systems. So this is really new, and I think it's very good to look at other things than just, I admit the word just is the wrong word here, fundamental rights. That is also because I think that when you read the GDPR properly, and you look at data protection by design and the data protection impact assessment, the GDPR is quite a naughty piece of legislation. It actually dares to say that companies have to implement protection and assess potential risks regarding the fundamental rights and freedoms of data subjects. So this is something that is going to be extremely interesting, because that means it's not just the checkbox mentality. Let's see if all the different principles, the legal basis, the right to object have been implemented, or if there are any risks there. No, it says fundamental rights and freedoms. That means non-discrimination, freedom of expression, and I think, but I'm sure this has been said on this conference very often and already for 11 years, the manipulability that is incentivized by the ad-driven content that we have now is extremely problematic, and I believe to push the discussion a bit further, to finally get some resistance from you, I believe that we really have to get rid of ad-driven content. Because if you have an algorithm, so if you're a business and you exist because of your ad revenue, and so do your potential competitors, many don't really have competitors, but your potential competitors, if you exist due to that revenue and you have an algorithm that decides with what sort of content that revenue goes up, and that algorithm then finds that more extreme content raises your ad revenue, and this is not new, this has been scientifically researched now, then we come into real trouble. This is about fake news, but more about manipulability, nudge theory gone crazy. But it's not nudge theory, it's the market, it's the perverse incentive structure that nobody really wants. So it's very important indeed to listen to these big companies when they say, please give us a level playing field, because now we cannot afford to train our algorithms in another way, which is of course technically very much possible.
Thank you. I'll just mention, I meant to say this at the start, sorry, but better late than never. If you have thoughts that you just are tweeting, which is great, I'll try to create a storify, collection of all the tweets and the video and so on in the next day or two. If you use the hashtag AI GDPR, that will make it easier for me to find your tweet and maybe even to interact with each other as we're talking now and later in the day. Thank you.
Yeah, hello. My name is Tobias Bräutigam. I'm with Bird & Bird, and I also teach information law at Helsinki University. My question is to Ben, is more maybe a comment or a challenge. Your argument was based on kind of 3 foots, basically, and I would kind of to take away one, if I may, and that would be the professions are regulated as well. They use ethics. They have done this for years. There was a panel in November at IAPP on lawyers and ethics and privacy. And then I was on this panel, I did a little bit of research, and actually whenever it matters for fundamental rights, whenever it's essential in Paul's words, there's no self-regulation. In Germany, there was even a judgment by the Bundesverfassungsgericht, I think already in the 80s, that lawyers themselves can't actually kind of make their own law. They can make up all kinds of funny rules, what to wear and so, but whenever it matters, it's not for the lawyer society, it's not for ethics, it's the realm of law. Thank you.
Yeah, so I don't think that legal ethics, medical ethics, or research ethics are self-regulation. They're very much imposed by parliaments or by other somewhat democratically legitimate bodies that come up with these sets of rules. And I would say with the actual enforcement of those rules, indeed you start getting into this realm of law, but the idea behind them is very much the ethical weighing of values in the particular case, given a particular set of principles that has been outlined, which comes kind of closer to ethical assessment than whatever it's called, what you do in a court.
Come on, you've got an LLM, you know the word.
The process of law. So yeah, I think it's professional ethics is definitely in between the two, but it's a strong articulation of ethical procedures within professions mandated by democratic institutions.
Great. Could you raise your hand, please, if you still would like to speak today? So we have 1, 2, anyone else? 3. That's great, because we've got 5 minutes. Speakers also, I'm going to ask you at the end just to give a 30-second conclusion, if you could be thinking about that, please.
Hi, my name is Floris Krijk. I work as a constitutional advisor to the Dutch government. I have a question for Mr. Nemitz. AI generally works with probabilities, and a lot of questions I get is that we run the risk that some principles are at risk of being quantified. So, for example, in the field of discrimination, let's say a recruitment algorithm has as an effect that people from a particular background have a 1% less chance of being invited for a job interview than people from another background. How do we approach, through legislation, these probabilities? So when is it bad? Is it at 1%? Is it bad when it's 20% less chance? My instinctual reaction is to say it should be 0%, but I don't know how to approach this.
So I think you're raising a very important question about machine learning, and I really struggle with this. And this question is the following. Machine learning works on past empirics. So it learns from what is. But as we know from Kant and others, what is does not allow us to conclude about what should be. And it's human nature to strive for the better. we criticize the work we do today and we become impatient about it, we're not happy with it, and we try to do better, we ask questions, we have dreams of non-discrimination, better society, and so on. And all this criticism, this asking questions, this striving for the better, the dreams, these machines do not have. So how do we maintain the drive of the humans, the effort? Maybe the effort fails, but still, you know, the human who administrates, for example, recruitment, in the normal process of things will be unhappy with certain results and will try to do it better. How do we maintain this drive if we take the practice which makes unhappy out of the hand of humans and just leave it to the machines? So I think that is really a very important question about our ability to innovate and to move forward, because actually with AI, you know, we are stuck in the past realities. And of course, the danger of replicating yesterday's discriminations, openly or covertly, is very, very high. So then there are some people who say, we can't use machine learning, and we shouldn't use machine learning to try to improve things, because machine learning will only be a copy of yesterday. And there I would say, well, this is where the law and also personal ethics come in. Those who build those machines must think about past unfairness, past discrimination, and I would say they should actually try to exclude those discriminations which they see and build machine learning systems which inherently are focused towards the more fair, the more legal solution. Now, how this is done and whether quantification as such is a problem, I don't know. I mean, I'm a great friend of facts and empirics. From a philosophical point of view, we would have to discuss this, but I would say if we are able to describe reality in a more precise way than we were able to do it before, namely with quantification, I would not say that quantification as such is definitely a bad thing. So, but I would say that if we see in the past certain discriminations and we want to get away with them, then these machines and machine learning must be circumscribed in its rules of learning and in the way it functions to do away with this discrimination. And we should have this ambition. And I would say we need the same type of discussion about this ambition to do better already and use the machines to do better, which we also have about, for example, the issue of explainability. I mean, 2-3 years ago, I was told from many technology people, neural networks can't be explained and you have to get used to it. The good effect of these things, you just live with it, no explanation. Then I think in the debate it became clear this is untenable. Certainly in the public sector, you need explanations for decisions due to the rule of law and so on. And now I hear a lot saying, yeah, actually we can do it, we can document, we can explain, either human explanation, machine explanation. So the market is also driven, because these systems of course want to be, or people want to sell them. The market is driven by debates like ours and by very clear demands on implementation of the rules which the law and society requires. And we should be very demanding here to technologists. And, the first, I can't do it, is not good enough.
Thank you, Paul. Okay, so we've got 2 final points. Yeah, please.
It's me. Hello, my name is Sagar Kumar. I'm a law student at the University of Göttingen. My question is to Professor Mireille. You brought up competition law, and I want to build upon what Ben said, that GDPR took 5 to 6 years to finally become law. And when I read the research that you mentioned by Professor Linsky that competition law should be more active, I have this question that, have we exhausted everything that GDPR offers before we ask competition law to come in? Especially, I take into the thing called accountability, right? I worked in the financial services industry for 10 years, and then the banking regulator takes a very proactive approach to regulating banks that pose a bigger risk, like the too big to fail. So they are regulated at a much higher level. So should we not regulate companies that are fairly big in terms of power, the power asymmetry between the consumer and the controller? Should we not hold them to higher accountability standards? Like, I built credit lending models like 10 years ago, and we were told, we knew, I mean, through training, internal training, that there are a certain set of variables that you cannot use, for example, zip codes that lead to redlining or something. So so paraphrase, my question is, before we go and touch competition law, I mean, should we not look at the GDPR mechanism to enforce fair markets, like accountability, maybe hold Facebook and Google to higher accountability standards than any random.com?
Well, I'm certainly against any random legislation, but actually, to some extent, I completely agree with you. I was at a conference in Washington, I think 1.5 years ago now, on platform economy, where everybody was talking about competition law and how we could ever get down to any sort of business with the big tech platforms. And my voice was, we have the GDPR. What the GDPR does with requiring data minimization is limiting the extent of data obesity that we now suffer from all around the place, very inefficient. Data obesity gives you pattern obesity. So you get all sorts of inferences that don't mean anything. If you put a lot of data together and then ask an algorithm to find a pattern, yes, it will, many, but they won't make any sense, so you need to do more to figure out what makes sense. So I think the GDPR, and not just data minimization, but notably purpose limitation, because it aligns with the basic tenets of data science, and I know many people will be very surprised or think I'm crazy, but if you do good data science, you must develop a task for your machine learning algorithm. If you don't do that well, you get crappy outcomes. So purpose limitation and the task that is developed in data science are aligned. So data protection law, I think, is the bottom line. If we don't do that, if we keep on treating people, for instance, like data engines and believing that all this AI works, we're in deep trouble, and then I think competition law won't even work. But still, and I'm going to move to Lina Khan and be slightly more specific and still keep it very, very short. So Lina Khan basically says, at the beginning of the last century, the idea was we need in economic markets diversity. We must not have monopolies, full stop. One sign of monopoly is a high consumer price. So if we see low consumer price, maybe there is no problem. The Chicago schools turned this around, and they said we need low consumer price, and one cause of high consumer price is monopoly. But if we have monopoly and a low consumer price, free services, there is no problem, because it was turned inside out. Now, that is very important. As long as courts apply competition law based on the idea there is a low consumer price, so we cannot intervene, we have a problem. So it might even be possible that if there is more thinking about this that reaches the court, that even with current competition law, we might get a long way, etc., etc.
Great. Okay, we only have a couple of minutes, so can our final question be brief, please?
Thank you. I'll be very brief. I'm a PhD candidate writing on GDPR, in particular, and artificial intelligence. So my question is, in fact, to Mrs. Hildebrandt and Mr. Nemitz. Do you think that, I got the impression that you think the GDPR is adequate to really regulate artificial intelligence and privacy by design and other principles are great, but what about the restricted applicability of the solely automated decision making? Do you think that it is really adequate in this sense? Thank you.
Very briefly, Paul and Mireille, please.
Yeah, so I think right now is the time to encourage judges to do the maximum which can be done, and data protection authorities on the basis of the GDPR. So on the issue of automated decision making and the related rights to information, meaningful information and so on, I have read the articles which say this is nothing, which doesn't go far enough and so on, but I don't agree. I think much of the wording of GDPR, when it's unclear, must be interpreted in light of primary law and its purpose. So I say this actually can go very far, and I would be happy if scientists, it's always interesting to say this is shit and, need a new law immediately, yes, but, I would also be thankful for a number of articles which tests the limits of interpretation according to the, state of art of the law, and, therefore encourage judges to give these provisions a protective interpretation, broad interpretation in line with primary law. So on this specific point, there is also already literature going in the other direction. And, but of course, it's true that beyond this, and many questions came up, there are areas like, liability issues and so on, where maybe new law is necessary. And by the way, it's true that GDPR took 4 years of negotiations, but data retention directive took 9 months. So it's not God-given that every legislation takes ages. It's a question of political will. And we have the European elections coming up, and everybody has choices to be made. There are interests which make it difficult to pass certain regulation, and there are interests which make it very fast to pass other regulations.
Very quickly, Mireille, if you can.
Okay, just one sentence. So the Article 29 Working Party European Data Protection Board actually said about the requirement of human intervention, so that automated decisions must be solely automated. So basically they said that does not mean that if a company or a government agency fakes human intervention, that we're going to count that as human intervention. And they said for human intervention to count as disqualifying a decision as an automated decision, there are 2 requirements. That human intervener must understand the decision. Wow. 1. 2, must have the authority to take another decision. Help desks do not fall under this. So I think if the court is going to follow the EDPB, we're in good hands.
Thank you. Okay, sorry, speakers, we don't even have time for 30-second summaries. I'm just going to ask everyone for a second time. We'll see if anyone has changed their mind. I know our speakers have presented much more nuanced positions than for or against, but this is the debate format. So, who would, again, vote in favor of the motion that this House believes that GDPR is insufficient to regulate AI? Please raise your hands. So still a large majority of the audience. Who would vote against that proposition? Who thinks GDPR is sufficient, perhaps with the extended interpretation and aggressive enforcement and meaningful professional ethics where people can be disciplined and so on? So congratulations, Ben, because he has persuaded quite a number of people in the audience. But thank you also, Mireille and Paul, for your excellent arguments. Thank you for all of your points, and our friend with the bell will be back any moment.